Following the Trayvon Martin George Zimmerman trial on his website, legalinsurrection.com. Professor Jacobson, thank you for joining us this morning. And I understood you were following the verdict in the George Zimmerman case while in a layover at O'Hare Airport. Not a bad place to get reaction. I'm interested in what your reaction was and others around you as you were watching this.
Sure, yeah. I would have missed the verdict, except that our plane was delayed for 5 hours. So a little bit of luck there, because I've been following the case since March of 2012. I didn't really get a lot of crowd reaction at the airport, but I did hear a lot of people before the verdict came down checking their phones, talking out loud about trying to see if there was a verdict yet. And it was pretty clear from the way they were talking that they were in favor of acquittal. My reaction was that the jury reached the right result. I mean, anybody who actually followed the evidence in the case, as opposed to the news reports or the spin or the other things going on, the evidence in the case clearly made out a very viable defense of self-defense under Florida law. I mean, it wasn't even a close call. And if you took those facts and applied them to the clear Florida law, I think there's no question that the jury reached the right result. Whether you like the result or not, they reached the right result.
Clinical law professor at Cornell University, William Jacobson, our guest. And when you look at what the case that was given to prosecutors, is there any way that they could have received a conviction from a jury following the judge's instructions?
Not if the jury followed the judge's instructions and listened to the evidence, the actual evidence in the case. What you had, and it was really a sorry spectacle from my point of view, from a prosecutorial point of view, you had a closing argument from the prosecution, which is what you normally hear from the defense, which is all but saying disregard the law. They didn't say that, of course. They can't say that. But what they said is, do what's right in your heart, language like that. I mean, that's what you'd normally hear from defense counsel. That's not what you hear from a prosecutor. And it was really because they didn't have the evidence. I mean, there was eyewitness testimony and other things which clearly established a reasonable doubt as to whether George Zimmerman was properly acting in self-defense. And if there's a reasonable doubt under Florida law, the reasonable doubt goes to the benefit of the defendant. You had an eyewitness, a disinterested, neutral eyewitness. There's only one person who had a clear view of this fight, and that person, John Good, testified during the trial that Trayvon Martin was on top, punching George Zimmerman what he described as mixed martial arts style, and Zimmerman's injuries were consistent with that. Under Florida law, if you have a reasonable fear of serious bodily injury, you're entitled to use deadly force. I think if you look at his injuries, you look at that eyewitness testimony, the only eyewitness with a clear view, clearly, I mean, this is a case that never should have been brought, and in fact, it was not brought. The original prosecutors on the case from the state attorney's office declined to bring a prosecution. And that led to protests, and that led to the governor appointing a special prosecutor. So, this is a case that never should have been brought.
As you mentioned at legalinsurrection.com, Professor Jacobson, the special prosecutor in this case, going back to April of last year with a shooting in February of last year, Angela Corey decided not to take the case to a grand jury and instead just filed a criminal information, which was then presented with an affidavit of probable cause. And yet there was information in that affidavit that seemed to be erroneous or misleading.
That's right. Under Florida law, she had a choice. Since it wasn't a capital case, there's no death penalty involved. If there was a death penalty, it would have to go to a grand jury to indict. But since it was not, even though it was obviously very serious and second-degree murder carries life imprisonment without possibility of parole, she took it. She did not go to a grand jury, and she just filed what they call a criminal information. When you do that, you have to have a judge, you have to submit a supporting affidavit, and a judge has to find probable cause. That affidavit, we now know, failed to disclose to the court many, many exculpatory facts, and what it did present was presented in a very skewed way, in some ways actually incorrectly. So, for example, in support of the affidavit, they say in support of the criminal information in the affidavit, it says that Trayvon Martin's mother identified her son as a person screaming for help during the incident based on a 911 tape. What they didn't say is that the father said it wasn't the son. Now, if they had put that in there, maybe a judge would have said, wait a second, maybe we need to have a little hearing on this. Maybe we need to take a little evidence before I'm going to find probable cause. And there were many other things. For example, the fight that they described, they simply indicated that there was a scuffle between Martin and Zimmerman. Well, if they had put in that affidavit what they knew at the time, because they had the witness interviews, that Martin was on top punching Zimmerman mixed martial arts style, a judge might have said, well, wait a second, this affidavit's not good enough. We need to do something more. Maybe we need to have a hearing on whether there's probable cause. And so what the prosecutor's office did is the first set of prosecutors having refused to bring the case, the special prosecutor submitted or had someone in her office submit what was a misleading affidavit, which did not inform the court properly of that, the factors that might be considered improbable cause. And now the affidavits that get submitted in that situation don't have to be, 50 pages long and recite everything, but the prosecutor does have a duty to the court not to submit a misleading affidavit.
Clinical professor of law at Cornell Law School, William Jacobson, our guest online at legalinsurrection.com. Legally speaking, William, what happens from here? Proposed from the Justice Department a possible civil rights case, a civil case perhaps from the Trayvon Martin family, but will any of those cases go anywhere?
Well, the civil case will not go anywhere because he's protected under the Florida statute from civil liability if he properly invoked self-defense. So the civil case against him is not going to go anywhere. In terms of the Justice Department, a fact that nobody seems to be aware of, they already had the FBI investigate whether Zimmerman was motivated by racial animus, and the FBI investigation came back and said no, that they had no evidence based on interviewing over 30 people who knew him that he had any racist feelings, acted on them, spoke about them, anything like that. So, there's nothing there. That doesn't mean the Justice Department won't give in to political demands and conduct an investigation, but the FBI already investigated it and already has found that there's no evidence of racism. And of course, the whole media spin on this is, white person versus black person. Right. But George Zimmerman's actually of mixed race background. One of his grandparents is black. His mother's Hispanic. He is white only for the media purposes. Yep.
We made this about race.
Exactly. I mean, the media and frankly, the Martin family. What they did is they hired a law firm in Florida, which is well known for doing civil rights types of cases, Parks and Crump. They also retained a public relations specialist, somebody who's done a lot of work for various causes, and they painted this case in order to get a prosecution as a racial incident. And there's absolutely zero evidence that it's a racial incident. And there's been really media malpractice in this case. Very famously, NBC News doctored a tape to make it look like George Zimmerman said he found Trayvon Martin suspicious because Trayvon was black. Well, in fact, the unedited tape shows that George Zimmerman never brought it up until he was specifically asked by the 911 operator to identify whether the person he thought was suspicious was white, black, or Hispanic.
And now NBC is facing a suit by George Zimmerman of their own, one that actually may be found, where they may be found liable.
Yeah, I'm not familiar enough to say what their likely liability is. I mean, it's so hard to sue a media entity when you're a public figure.
But they doctored a tape.
So that's but I'm just not familiar enough with that defamation law to know whether it's got a strong likelihood of success. But certainly their actions were despicable, and they fired several people because of it. And that really caused a lot of damage, because it's one thing for the lawyer for the family to suggest that this was a racial incident. It's very different when NBC News runs a tape which purports to prove it. And that tape purported to prove that when he called 911, that what he said to the operator was, there's this guy, he's suspicious, he looks black. That's not how the conversation went down. The he looks black was only a couple of questions later when they specifically asked him to identify the race of the person. So, yes, and that's just typical of how the media... Another thing that the media does, I mean, I can't... Even to this day, to this morning, people say, well, if only he had not got out of the car when the police told him not to.
Yep.
Well, that's a complete, fallacy, that the police never told him not to follow Trayvon Martin. And, in fact, the police said they don't give those sort of instructions because they don't want liability. And when that conversation took place, he was already out of the car. So that's just another example of how the media has perpetuated certain narratives that people absolutely believe. I mean, I was at a meeting this weekend in Chicago, and a woman I respect a lot, intelligent person, said, as the one thing I can't get past as a mother is that he got out of the car when the police told him not to. And it's like, well, wait, no. I had to tell him that's not what happened. I mean, I actually heard the testimony at trial. I've seen the evidence. That's not what happened. But that's, most people, it's not shocking. Get their news from, 1 minute clips on the nightly news. I mean, with all the information that's available on the Internet elsewhere, tens of millions of people still get their news from the half-hour nightly news.
You are entitled to your own opinion, just not your own facts.
That's right, and the facts here are pretty overwhelming. And there were a lot of facts not presented to the jury, which, had they been presented, I think would have been even more overwhelming in support of self-defense. For example, on Trayvon Martin's cell phone, just days before this incident, he was bragging via text message to a friend about how he had learned how to start a fight. And he said, you start that fight by punching somebody in the nose, because that stuns them and that gives you, an advantage. And in fact, that's what he did to George Zimmerman. I mean, that would be consistent with how George Zimmerman, of course, not knowing that Trayvon was sending those text messages, that George Zimmerman, it's consistent with his story that the way that fight started was with Trayvon landing a blow on his nose, essentially trying to land a knockout punch to begin with. So there are a lot of things that I think, another issue of how the media malpractice is that the family released photos of Trayvon very early on when he looked much, much younger than he was at the time of the incident. And so you had this image created in the public mind of essentially a 12-year-old or somebody who looks like a 12-year-old versus this 28-year-old guy. And in fact, Trayvon Martin, in his text messages, which the jury never heard, bragged about his fighting prowess and how he was able to take a blow and all those other sort of things and all the fights he had been in. A very different picture than was presented to the jury, and certainly a very different picture than what you're hearing on the street protests and elsewhere, which make it seem like there was, just this kid who was just getting Skittles and who was viciously attacked just because he was black. I mean, that's not what the evidence shows.
LegalInsurrection.com. It's made me feel a lot smarter and has kept me informed throughout this trial of the facts. Our guest, clinical professor of law at Cornell Law School, William Jacobson. A pleasure, sir. Thank you very much, and I look forward to having this opportunity again.
That would be great. Take care.